So Section 2740, 800 of the Residential Landlord and Tenant Act, it talks about undertaking an appeal, an order, staying, execution. And subsection B of this section states that it is sufficient to stay execution of a judgment for ejectment that the tenant sign an undertaking that he or she will pay to the landlord the amount of rent as it becomes due periodically after the judgment was entered. So you may be wondering, what is an undertaking? So an undertaking is a written promise offered as security for the performance of a particular act that is required in a legal action. So your written promise, which you will see in the next slide, is a promise that while this appeal is pending, you are agreeing to make periodic payments to the court in place of rent. So that is your promise. That is the undertaking. And on this next slide, you will see a picture of the bond to stay execution on appeal. And this is your written promise right here. And I've included, you can find this document, of course, on the SC Court's website as well. And I have also included a link for you to view this document. It's important to note, and I put here 2740 800E, if the tenant fails to make a payment within 5 days of the due date according to the undertaking and order staying execution, the clerk, upon application of the landlord, shall issue a warrant of ejectment to be executed. So it's important that you keep your promise, this written promise, to make payments to the court while the appeal is pending so that you can remain in the dwelling unit. Because when you make this promise, that writ of ejectment that was issued against you when the magistrate court decision was in favor of the landlord, that writ will not be executed while the appeal is pending if you continue to make these payments. If you do not continue to make these payments that you are promising to make to the court, then you will not be able to continue with the appeal. The action will be dismissed, and you will need to vacate. A writ will be executed, and you will have to vacate the property. So it's important to keep this promise that you're making and acknowledge that it is a written promise, and that's why I explained what an undertaking was, so that you can understand what it is that you're filling out and providing to the court, a written promise. Now, this document, you will state the date on which the magistrate court ruled in favor of the landlord. You'll state the who, when, where, and how when it comes to paying your rent. And if you look at the bottom, so after you've filled out the applicable information at the top and you've dated it and you've signed your name, underneath where it says tenant, you'll see that last paragraph where it says, upon execution of the bond, execution on the judgment of ejectment is hereby stayed until the action is heard on appeal and decided by the circuit court. If tenant fails to make any rental payment within 5 days of the due date, upon application of the landlord, the stay of execution shall dissolve. The appeal by the tenant to the circuit court on issues dealing with possession must be dismissed, and the sheriff may dispossess the tenant. So what I stated earlier, it's once again given to you in the bond to stay execution on appeal, repeating the importance of making sure you understand what you are filling out and what will happen if you do not keep this written promise. Now, the fee for filing your appeal in circuit court will be $150. If you cannot afford to pay the filing fee, you can file with the court a motion, with the circuit court, a motion and affidavit to proceed in forma pauperis. And you can see that document to the right of the slide. I've also included a link to the SC Court's website where you can also find this document. And what you're saying is you cannot afford to pay the filing fee. You are asking that, you're requesting that the court waive the fee. And at the bottom, you can see here that the court needs to decide, of course, whether to grant or deny your motion. It is important to note that your appeal cannot be approved until this decision is made by the court. And so it's important that you keep that in mind moving forward, especially if you're limited on time. But just know that this is an option. If you cannot afford to pay the filing fee, you can file a motion affidavit to proceed in forma pauperis.